वित्त मंत्री निर्मला सीतारमण की प्रेस वार्ता में
We are meeting on matters which relate to the Ministry of Corporate Affairs. So I'm thankful that we have MOS Rao Indrajit Singh ji today with me and also Secretary Corporate Affairs. The matter that I'd like to draw your attention on is about the Supreme Court's order yesterday on the Antrix Devas Issue. You are aware that Antrix had approached the NCLT asking for liquidation of Devas. And that was sometime early 2021, in January of 2021. Post which the final order of the NCLT was issued in May 2021, which ordered a liquidation of the Devas, which the Devas went on an appeal to the NCLAT. The NCLAT also gave its order in September of 2021, upholding the order issued by NCLT that it should be indeed liquidated. Post that, Devas again went on an appeal to the Supreme Court. And the Supreme Court, after hearing both the sides, gave its order yesterday, upheld the NCLT and NCLAT order for liquidating Devas. The Supreme Court has actually given a very comprehensive order. And in fact, I'd like to draw a few of their observations as a part of their judgment. But before that, I want to just broadly mention to you what this is all about. I'm sure many of you all who've been watching this whole process since 2005, when Antrix entered into an agreement with Devas, and that itself became a controversy during the UPA government. Agreement was signed during UPA in 2005, and post the agreement, it took 6 full years for the UPA themselves to cancel the order in 2011. And even when they cancelled it, glimpses of what was completely wrong against national security, that it was a fraud upon the people of India, a fraud on the treasury of India, and a fraud against the country, was obvious. Several of you in the media have covered it then. And it was therefore sometime in February 2011 that the UPA government itself thought it fit to cancel this order, cancel this agreement between Devas and Antrix. There are several statements given in that context by the Congress ministers then. And not to forget that year, just a couple of months before the cancellation of this, a sitting minister was arrested in the UPA government. And that was also a big scandal. So the cancellation comes in the sequence of one scandal, minister gets arrested, the next scandal, where the agreement between Antrix, which was part of the ISRO's own commercial wing, with Devas, which was a private entity, and giving away for pittance a rare S-band spectrum which is only used largely by defense forces. So this kind of a selling of primary endowments, whether it is under the soil as mineral wealth, or wavelengths, or satellites, or spectrum band, and anything else, giving it away to the private parties and making a deal out of it, marks the feature of the Congress governments. And this today, after nearly 10, 11 years of struggle, we've had Supreme Court come out with a comprehensive order. Just a proof of how repeatedly the Congress party, when in power, misuses its position, allows blatant selling of resources of the government, resources of the people of India for pittance. The statements given then clearly tell you how brazen this attempt was. The cabinet didn't even know about such a brazen agreement, whereby 90% of yet to be launched satellites were already agreed and given away to private parties. The GSLV 6 and GSLV 6A were not even launched yet. The cabinet hadn't even approved it yet. But 90% of these two satellites' utilization was already through an agreement given away to a private party. In 2011, in an interview to a television channel, the telecom minister then, and this is Shri Kapil Sibal, said that the cabinet was not even aware of the details of Antrix Devas deal. ISRO is something which comes under the PMO. Dr. Manmohan Singh in February 24, 2011 says, there was no question of Prime Minister's office being asked to approve this deal. It never came to that level. Unquote. And it further says only the launch of 2 satellites came to the cabinet. It did come to the Space Mission Commission. But it, that is Devas Antrix deal, was not mentioned even in the cabinet note that there was a specific commitment under this agreement. The Prime Minister clarifies. What did Devas offer? That itself shows how blatant this agreement was and that it was a fraud. Just listen, today we have the benefit of hindsight. 10 years later, we know what are the kind of services which we are getting through telecom and what we may or may not get through the satellite, which is not in the reach of everybody. Devas offered a bouquet of services known as Devas services through a device called Devas device in a hybrid mode of transmission, which is a combination of satellite and terrestrial transmission, and which is called Devas technology, but none of which existed when they signed the agreement, nor existed when the agreements were cancelled, and probably to an extent doesn't exist even today. That's where the fraud begins. And the CAG, which comes out with a report in 2012, says, first of all, these are not within the scope of the SATCOM, which is Satellite Communication Policy, and approving of digital multimedia broadcasting or direct-to-home broadcasting. All these services are the prerogative of the Government of India. And no any one particular commercial entity belonging to any department could give that away. But Antrix gave it away, did not tell the cabinet. And it went on till today, becoming a big legal tussle. Of course, the CBI, since 2015, has got cases going on under the PCA, Prevention of Corruption Act. The ED has also come in with a first information report in 2015. Some assets were attached. I'm just very quickly moving to the fact that internationally too, there are now arbitral awards coming up. Just to highlight what this greed of the UPA has done. They may have cancelled the order in 2011, but Government of India under Prime Minister Modi is fighting in every court to make sure that this fraud doesn't get away. Do you want to know the irony of how this has been handled by the government? In 2011, when the whole thing was cancelled, an arbitration set course, meaning Devas went with the ICC saying cancellation was wrong, they should be made good for it. In July 2011, they were asked to appoint, Antrix was asked to appoint an arbitrator from its side. Devas would do it from their side, arbitration will go on. Antrix did not even appoint an arbitrator, continuing this fraud. Government of India did not tell Antrix that he should appoint an arbitrator and go fight. They did not, they just kept off, saying, whatever happens, let's see. Having cancelled it, they did not appoint an arbitrator to fight for the right and defend the Government of India. Did they leave it there? In August 2011, again they were reminded, appoint somebody for this arbitration. And they were given 21 days only to appoint an arbitrator to fight for it, so that the Government of India doesn't have to pay for having cancelled and rightly cancelled it. Even the 21 days went away, they did not appoint an arbitrator, which means what couldn't be given through the deal, through arbitration and everything else, the fraud that was perpetrated on us would get paid in the name of damages. That arbitration award had to come in 2015 after Modi's government comes and we take it up all in seriousness and fight from then. Even worse, even in 2011, for having given away the S-band, which is a very sensitive band, which is a spectrum band, which is very rarely used and by defense only, for having given away the S-band for a throwaway price, they did not even invoke national security when the arbitration began. It's an outrageous case whereby a rare endowment of the people of India, the S-band spectrum, the satellite which goes up, are all given away to petty cronies of the Congress party. Some of them were abroad, some probably within this country. And half-hearted attempts to bring justice to this case were taken up. I told you how they did not appoint an arbitrator. Even after reminder, they did not invoke national security as an important clause. That led to Devas becoming brazen and going to all the international courts and claiming damages. I'll just give you a picture of how much of damages they are claiming. You'll understand the seriousness of this matter. The domestic commercial arbitration between Devas and Antrix is of roughly $562.5 million US dollars plus interest from 2015. The two sets of the shareholders, the Deutsche Telekom, I think, Singapore, and 3 Mauritius investors, have obtained awards using the bilateral investment treaty clauses. Each, meaning one has got 93.3 million US dollars, and the other one is 112 million US dollars. You can imagine what a scandalous agreement that was. A laid back, just get the problem out of my way kind of an approach in 2011 when they cancelled it. And even after that, when they did not appoint an arbitrator, and even after that, they did not even invoke national interest or national security, that till today, we are fighting one after the other to save taxpayers' money, which would have otherwise gone for paying all the damages because of this scandalous agreement. It was a fraud from the first place. And I'm glad that the Supreme Court has called it out. And simultaneously, let me remind you that the first generation bilateral investment treaties, which did not have very many clauses which are important for Indian investors, was brought to an end, terminated in 2015 after Prime Minister Modi came. It's become null and void since after 2016. A model BIT is now being negotiated with very many countries. And just to highlight to you what that first generation BIT did not have, and as a result of which we are facing a lot of trouble, is it had issues of taxation also being interpreted as part of being a part of BIT. Taxation can never be part of any of the agreements. It's a sovereign domain. Today, interpretations are being given even about taxation in such matters. Second, there's no chapter on investor obligation in any of those first generation BITs. Investor has no obligation. He may fulfill an agreement or not, but he can claim all the rights. Whereas the model BIT today includes all that. And national security could never be invoked, probably under the way in which that was drafted. So BIT is happily being touted and interpreted against our own interest. And I'm very grateful that the Prime Minister in 2015 said, no, we'll have to redraft all these agreements. And 2015, it was annulled, meaning effective 2016. Although, of course, the duration for which it had to run, it'll run, the grandfathering will happen for those who invested during those times. Sorry, friends, it's a bit longish opening statement, but I just want to draw your attention to a few quotations from the Supreme Court's observation. I'll just highlight one or two, and I'm sure many of you all would be able to take it from the judgment itself. I'll share the copy of the judgment with you all. Para 12.A of the Supreme Court verdict. I have the copy with me. I can share the copies with you later. Para 12.8 says, a total amount of 579 rupees, Indian rupees, was brought in by Devas. But almost 85% of the said amount was siphoned out of India, partly towards establishment of a subsidiary in the USA, partly towards business support services, and partly towards litigation expenses. So you bring in an investment money, you take it away and fight all the arbitration outside with that money and call that as investment made in India. Fraud. a total, and I'm quoting from para 12.8, a total amount of 579 rupees, Indian rupees, crores, was brought in, but almost 85% of the said amount was siphoned out of India, partly towards establishment of a subsidiary in the US, partly towards business support services, and partly towards litigation expenses. Para 12.8 again. The manner in which a misleading note was put to the cabinet. This is the Supreme Court order. The manner in which a misleading note was put to the cabinet, and the manner in which the minutes of the meeting of the TAG, the Technical Advisory Group, subcommittee, were manipulated, highlighted by the tribunal, also shows that the affairs of the company were conducted in a fraudulent manner. Another paragraph in page 127, that the officials, some of them, not all, that is my addition also, that the officials of the Department of Space and Antrix were in collusion, and that it was a case of the fence eating the crop, and also allowing others to eat the crop by joining hands with third parties. There are more such quotes which I'd like to read out, but for now I will highlight the fact and conclude my opening statement.
Thank you, ma'am.
Veerappa Moily ji, sorry, I had one little conclusion. Veerappa Moily ji, the then minister, in February 2011, 17th in fact, says, the government cannot afford to grant, I'm quoting, the government cannot afford to grant the S-band to anyone, including Antrix, because of strategic reasons. That's Veerappa Moily ji saying then. The Prime Minister is not at fault, nor the government is at fault. Veerappa Moily ji again. This is a cabinet decision. What is a cabinet decision? The cancelling. So, knowing very well that a fraud has happened, cancelling it after it's come out in the public, if not in full, but at least partly, and then trying also to let it go and let the government of India pay the damages for it. And you saw the extent to which government of India has to pay damages, if at all. This fraud has not been established, and I'm very grateful that the Supreme Court of India brought this matter in a comprehensive order. Now we shall definitely take this order and defend our position, Government of India's position, that position where this order was cancelled even by UPA in 2011, 6 years after the agreement was originally signed, and make sure justice is done against this fraud which was perpetrated. Very much under the nose of UPA's own government. Proves clearly how Congress party works. Goes along, tries to make money through cronies, and when caught, behave as though nothing has happened, but the loss will be borne by Government of India. No, loss shall not be borne by Government of India. This is Prime Minister Modi's government. We shall fight it till the last. And this is a fraud. This has come out very clearly through the Supreme Court order. And now it should be the Congress party's turn to explain how this was allowed, explain how the cabinet was kept in dark, and explain how it took them 6 full years to have this kind of a fraud perpetrated on the people of India. They should have no moral right to speak about, oh, crony capitalism, you're helping so-and-so, this is an agreement with so-and-so. The master game players in this are the Congress party, and today, with yesterday's Supreme Court order, we are able to clearly show this. Thank you.
Thank you, ma'am. We'll now take some questions. Okay. 15.
Very good evening, ma'am. Sapna here from CNBC TV 18. Ma'am, two quick questions on the Devas matter. Does the Supreme Court judgment directing liquidation of Devas have a guiding force or a binding effect on the American Canadian courts hearing execution proceedings? Number one. Number two, ma'am, criminal proceedings launched by CBI ED against Devas haven't been taken to the logical conclusion yet, no conviction yet. How difficult will it be for India to keep the Canadian American courts from attaching Indian assets without a formal conviction, ma'am? Thank you, ma'am.
First of all, this case, and that is why I have Secretary, MCA, Minister of State, MCA Corporate Affairs with me. This was a case which went through the NCLT and the NCLAT for liquidating the fraudulent company Devas. The company probably wasn't fraudulent, but the shareholders knew all the fraudulent practices which was going on in terms of the agreement Devas with Antrix. Something on which they did not even have the rights or the patents, they came into agreement with and promised that they will deliver on things on which they did not even have the rights. I would like to just recall the Supreme Court's order there. Just 1 minute, I'm sorry to take this time of you. No, sorry, it's going to take a time, but I'll show it to you. That the court has very clearly said, yeah, sorry, I've got the order here. The finding of the tribunal, which is the NCLT, that A, public largesse was doled out in favor of Devas in contravention of the public policy in India. B, that Devas enticed Antrix ISRO to enter into an MOU followed by an agreement by promising to provide something that was not in existence at that time and which did not come into existence even later. C, that the licenses and the approvals were for completely different services. And D, that the services offered were not within the scope of SATCOM policy are actually borne out by all the records. This is in page 123 and 124. So, very clearly, the fraud has been established. So, this was for liquidating the company. And therefore, I was looking at that aspect and showing it.
176.
Good evening, ma'am. Arup from Business Standard.
Welcome.
Ma'am, just last week, a Canadian court ruled that Air India is the alter ego of the sovereign of India and that Devas can go ahead and seize some assets of Air India. So, number one, how does yesterday's Supreme Court judgment affect this and what the government of India stance in this fight? And number two, will it impact the divestment, the privatization process which is going on with Tata Sons?
I, first of all, will answer the second question. The Supreme Court, in its order, very clearly talks about even that, saying, will it send a wrong message to the investors if you pass this order about the fraud which has taken place? And the court's order that itself says that this shall not give a bad, negative message or wrong message for investors. What it does say, and I quote here, paragraph 13.6, we do not know if the action of Antrix in seeking the winding up of Devas may send a wrong message to the community of investors. But allowing Devas, this is very important, but allowing Devas and its shareholders to reap the benefits of their fraudulent action may nevertheless send another wrong message, namely that by adopting fraudulent means and by bringing into India an investment in a sum of rupees 579 Indian rupees crores, the investor can hope to get tens of thousands of crores of rupees even after siphoning off 488 crores of Indian rupees. You bring in 579, you take away 488, but you still think through these arbitration and court cases you can win tens and thousands of crores, is a fraud. And therefore this paragraph 13.6 very clearly says that if this is not called out, which is what it does, it calls out the fraud. If this fraud is not called out, it will also send a wrong message that you can come to India with 579 crores, take away 488 crores, but still make tons and tons of rupees by just going to the court and winning cases. That's the fraud which has been called out. I'm grateful that law has taken its own course, but shown that India is not a land where you can come and cheat the people here. No? Yes. First of all, this order itself shows that what a fraud it has been. And in fact, the Supreme Court has also said, in a situation of rule of law in any country, can a fraud of this kind be entertained? And therefore, a fraud of this kind cannot be entertained even in such claims. The court has said even on that. I don't want to go on reading every bit, but it is a very powerful statement that they've given.
126.
मैं अजय मिश्रा दूरदर्शन से.
Yeah, just to add on to it, I found the paragraph, thank you to Secretary, 13.5 paragraph. A product of fraud, that paragraph has other lines also, but I'm reading this bit. A product of fraud is in conflict with the public policy of any country, including India. The basic notions of morality and justice are always in conflict with fraud, and hence the motive behind the action brought by the victim of fraud can never stand an impediment. Yeah.
मैम, अब सवाल यह है कि क्या अब इस कंपनी को लिक्विडेट करने की प्रक्रिया शुरू की जाएगी, नंबर 1. दूसरी बात यह कि कुल हर्जाना कितना देवास ने क्लेम किया है अंतर्राष्ट्रीय अदालतों में, और अब सरकार उसको किस तरह से फाइट करेगी. थैंक यू मैम.
हाँ, लिक्विडेशन का प्रोसेस शुरू हो जाएगा, मगर मैं रिक्वेस्ट करती हूँ सेक्रेटरी उसमें थोड़ा.
नाउ दी क्योंकि वाइंडिंग अप की अब जो वाइंडिंग अप का ऑर्डर दिया गया था एनसीएलटी द्वारा, वो उसके बाद उसको चैलेंज एनसीएलटी में हुआ, और 19 जनवरी को ही एनसीएलटी ने प्रोविजनल लिक्विडेटर अपॉइंट कर दिया था. 25 मई को वाइंडिंग अप ऑर्डर एनसीएलटी ने दिया था, और उसके बाद वो चैलेंज हुआ तो एनसीएलटी में ये अपील भी डिसमिस हो गई थी 8 सितंबर को, और सुप्रीम कोर्ट जजमेंट हैज़ अपहेल्ड द वाइंडिंग अप ऑर्डर, एंड नाउ द वाइंडिंग अप प्रोसीडिंग्स विल स्टार्ट. The liquidator जो है अभी अपॉइंट हो चुका है ऑलरेडी, और इसके बाद में जो भी कानूनी प्रक्रिया है, जो प्रोसीजर है उसका वाइंडिंग अप का, उसके अकॉर्डिंग ये प्रोसेस अब स्टार्ट हो जाएगा।
आपका वो दूसरा प्रश्न के लिए बीआईटी आर्बिट्रेशन के तहत इंडिया जर्मनी बीआईटी का 93.3 मिलियन प्लस कॉस्ट एंड इंटरेस्ट यूएस डॉलर्स है, वो इंडिया जर्मनी बीआईटी का। इंडिया मॉरिशस बीआईटी का 111.29 मिलियन प्लस कॉस्ट एंड इंटरेस्ट, वो दूसरा है। तीसरा कमर्शियल टर्मिनेशन अवार्ड बीआईटी का तहत नहीं, वो अलग है, वो 1 बिलियन का।
56.
This is Shrimi from the ET. Ma'am, just a clarity needed here that will you wait for this whole winding up process to complete to challenge, arbitration award in the several foreign courts, etc., because the amount is huge. So just wanted to know whether you are waiting for that or you will simultaneously file, or contest the amount which has been filed in the arbitration court.
Well, the order has come from the Supreme Court yesterday, and we have spent some time yesterday looking into the details of the order, and that is why I have come to meet you all today. But certainly we'll sooner meet up interdepartmentally because it involves 2 or 3 departments concerned of the Government of India, and then take a call on how we want to proceed.
Ma'am, one more clarity on the part that, as you rightly mentioned, and even the court mentioned that about 85% of the money has been siphoned off. So what exact action like the agencies are taking on that front? Enforcement Directorate, you said that some asset has been seized. CBI has filed prosecution complaint in 2016. What more action we will see in this matter?
Well, first of all, the CBI and ED are going in there very clear by the acts which govern them. Some of the assets, which are not very many, are in the form of fixed deposit, and some properties, I think, that the ED and the CBI are looking into. I may not be able to give you the details because today I'm looking at the company getting liquidated, and company which is getting liquidated, which was a fraud in its first place in the agreement. All that has got established. We are looking at that side of it today, but sooner, post this order of the Supreme Court, I will be holding a meeting with all those departments and seeing and also the law enforcement agencies to see how best we can proceed.
174.
Ma'am, one follow-up question on the implication on international courts. Do international courts and arbitration tribunals accept, the judgment of a domestic court as validation of a case of fraud made against the other party as sufficient ground for not fulfilling the obligations of the arbitration award? Ma'am.
First of all, it's the Supreme Court of India whose order that we are taking up and presenting before those arbitration. Second, that is where I wish Government of India, even as it cancelled the order in 2011, understood the gravity of the fraud that had taken place and also understood the gravity of the cancellation and its fallout and its implication, and built up the case from then in a tight manner, putting up the right arguments of national security and of also the fraud that has been perpetrated on an entire prerogative of Government of India. There is one commercial wing of a department giving away the rights. These are things with which initially, even from 2011, the case had to be built up, which Prime Minister Modi, after coming in 2014, understanding the gravity, made all the departments work together so that this fraud is rightly placed, and it is only till yesterday that we could come up with it. So we will take all these facts before the court, because no country which respects rule of law will ignore these facts.
Okay, 107.
Ma'am, तरुण शर्मा फ्रॉम जी बिजनेस। मैम, आपने सीबीआई ईडी की बात करी, लेकिन ये पूरा केस मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स ने बहुत अच्छे से हैंडल किया और कल आपको सुप्रीम कोर्ट में काफ़ी एक बड़ा केस आपने जीता है। मैम, क्या कॉर्पोरेट लॉ के अंदर भी जो ब्यूरोक्रेट्स थे या उस समय या जो पॉलिटिशियंस थे, क्या उनको इसमें स्कोप में रखा जाएगा? क्योंकि कॉर्पोरेट कंपनीज लॉ में भी कई सारे प्रोविजन है, एसएफआईओ है। क्या मैम, क्या उसमें एक्सपेंशन इस केस में हम देख सकते हैं?
मगर ये कंपनी का सैंक्शन के द्वारा नहीं, दो कंपनीज, एक सरकारी इन अ वे इंडिपेंडेंट कंपनी बट सरकार के द्वारा कमर्शियल कंपनी, और दूसरा एक प्राइवेट कंपनी के आपस में जो एग्रीमेंट साइन हुआ उसके ऊपर है। सो उन सबको अध्ययन करके ही इतने दूर केस ले आया गया है। हम इसको भी शामिल करेंगे, इस सुप्रीम कोर्ट का वर्डिक्ट को भी।
If there are no further questions, with your permission, ma'am. Oh, sorry, you come back again. Okay, sir. Please go.
मैम, एक सवाल बार बार ये उठता है कि जब सरकार को ये पता चला कि यूपीए सरकार के दौरान इतने बड़े स्तर पर जो एस बैंड जो कि रक्षा मंत्रालय द्वारा इस्तेमाल किया जाता है उसको निजी कंपनी को बेचा गया, कौड़ियों के दाम बेचा गया, और इतने सीरियस फ्रॉड प्राइम मिनिस्टर ऑफिस के लेवल तक आपने मेंशन किया, कैबिनेट नोट का जिक्र किया, किस तरह से कैबिनेट ने नोट में इस बात का जिक्र नहीं किया, वो भी अपने आप में एक फ्रॉड था। इतनी सारी जानकारियों के बावजूद भी सब लोग ये समझना चाह रहे हैं कि इतने सालों में कोई एक्शन क्यों नहीं लिया गया, किसी को जिम्मेदार क्यों नहीं ठहराया गया, और अब क्या इसके आगे जनता का विश्वास सिस्टम पे, लॉ पे करने के लिए क्या कदम उठाएगी सरकार? क्योंकि कांग्रेस को बार बार आरोप करना कि आपको बोलने का हक नहीं है तो एक बात है, लेकिन फिर से इतने सालों के बाद मौजूदा सरकार ने क्या किया इसके खिलाफ?
नहीं, इतने दूर तक हर लेवल पर एनसीएलटी, एनसीएलएटी और सुप्रीम कोर्ट, और हर एक में दोनों पक्ष का सुनना, फिर 2-3 वायदा के बाद दोबारा कोर्ट मैटर को कंटिन्यू करना और ऑर्डर ले आना, ये सब इस सरकार के आने के बाद शुरू हुआ। और बार बार आरोप लगाना, आरोप हम नहीं लगा रहे हैं भैया, आप उनके स्तर पर ही सोचिए। 2005 में जो गलत समझौता हुआ दो पार्टीज के बीच में, उसको कैंसिल करने के लिए 6 साल बीता गया, और उसके बाद उस सरकार गलत जो कैंसिलेशन के कारण बना और कैंसिल भी हुआ, उसके बाद न्याय दिलाने के लिए और पैसा, जनता के पैसा को बचाने के लिए उनके तरफ से कोई कार्रवाई नहीं की, कम से कम आर्बिट्रेटर को अपॉइंट नहीं की। गलत इतने सारे एक के बाद और उनके द्वारा इतना गलतियां हुई, और हमारी सरकार आने के बाद ही हर लेवल पर एक्शन हो रही है। मोदी जी के आने के बाद ही हर डिपार्टमेंट को बिठा करके इसका गहराई समझ करके एक्शन लेने के लिए हमारी तरफ से कोशिश हो रही है, और इतने सारे केसेस को हम बचाने के लिए इतनी दूर तक ले आने वाला हमारी सरकार है। उनके सरकार के द्वारा कुछ भी नहीं हुआ, गलती हुआ उसका कैंसिल करने का मजबूर हुआ, मगर उसके बाद न्याय दिलाने के लिए कुछ नहीं हुआ, क्योंकि पैसा जाने दो, किसका पैसा है, सरकार देगी। ऐसे अप्रोच कांग्रेस का है, इसीलिए बार बार आरोप में तक नहीं जाऊंगी। आई विल नेवर बिकम टायर्ड of telling the truth before Congress. What do they say repeatedly? Who can speak truth to power? It's one thing to go on using cliched phrases. मगर एक बार क्या राहुल गांधी जी इसके विषय में कांग्रेस में चर्चा की है? इतने बड़ा घोटाला, देश का इतना बड़ा नुकसान कांग्रेस पार्टी के सरकार के समय हुआ, प्रश्न पूछा या उस ऑर्डर को कैंसिल करके फाड़ करके फेंका? कुछ किया? कुछ भी नहीं किया। मोदी सरकार आने के बाद ही इतना प्रयत्न चल रही है, जिसके वजह से आज सुप्रीम कोर्ट में हमें सफलता मिली। सो कांग्रेस को बार बार कहने में संकोच नहीं करिए भैया, बार बार आप भी पूछना चाहिए कि मास्टर ऑफ करप्शन, इस हद का करप्शन कोई और कर नहीं सकते हैं भैया। मैं पूछना चाहती हूं आप सबसे, 2014 से एक कहीं सुनने में आया करप्शन मोदी सरकार में? मगर ये है लेवल ऑफ करप्शन ऑफ यूपीए, और सरकार 10 साल से इसके इतना मेहनत करके कोर्ट में जीत कर आने के लिए इतना कदम उठा रही है. That's the level of fraud that Congress party perpetrates and accommodates.
We have another question at 61.
मैम मैं शैलेश यादव हूँ ANI न्यूज़ एजेंसी से. मैम जैसे कि आपने बोला कि ये पूरा स्कैम है, फ्रॉड है, तो इस फ्रॉड के पीछे कौन है? कांग्रेस है या कोई पॉलिटिशियन है या PMO है या कोई मिनिस्टर है? किसी एक दो का नाम अगर आप बता सके तो.
कांग्रेस है तो मैं बार बार बोल रही हूं, आपको शायद इतना स्पष्ट से सुन नहीं दे रही. कांग्रेस है. इट इज अ फ्रॉड बाय कांग्रेस, ऑफ कांग्रेस एंड फॉर कांग्रेस. आप ऐसे समझ लीजिए. इस स्तर का फ्रॉड नहीं तो नहीं हो पाएगा. इस स्तर का फ्रॉड इज बिकॉज इट्स फॉर कांग्रेस, बाय कांग्रेस, ऑफ कांग्रेस. और जब तक ऐसे उनका विषय बाहर आते जाएगा, हम जरूर बोलेंगे उनके लेवल ऑफ करप्शन के ऊपर. और इतना शेमलेस करप्शन है.
Thank you, ma'am. With your permission,
Thank
we'll
you.
close the
Thank
press conference now. Thank you, friends.